Hello and welcome to another AIIA webinar. By my count, this is our 35th webinar, which is testimony to the hard work of our state and territory branches across Australia. Well, it's been almost exactly a decade now since American and Chinese officials trade barbs on the South China Sea and told each other that the South China Sea was a matter of their respective national interests. Since then, we've had confrontations, court cases, and artificial islands. One might think that the tensions over the South China Sea would be mollified given the recent international focus on COVID-19, but one might also be wrong. To discuss the current tensions on the South China Sea, we have with us an expert of profound intelligence, Dr. Lynn Kuok. Hi, Lynn. How's it going?
Good, thanks. How are you, Bryce? Thank you for that very kind introduction.
I'm great, thanks. Lynn is the Shangri-La Dialogue Senior Fellow for Asia-Pacific Security at the International Institute for Security Studies. She's based in Singapore, but she's also a Senior Research Fellow at Cambridge University. She's held fellowships and positions at the Brookings Institute, Yale, Harvard, the Center, the CSIS, and the National University of Singapore. She's responsible for the Asia-Pacific Regional Security Assessment, which came out this month. And if you're watching the YouTube version of this event, I'll link to it up here so you can find out where to get your copy. She's also a friend of this institute. She's taken part in our Indo-Pacific Research Forum, which we held last year and in Canberra, and this year in Tokyo before the COVID crisis. And if you want to get an idea of what that project's about, I'll link to it again up here. So, with what is sure to be a fascinating event, I will now turn things over to Lynn for her presentation.
Thank you so much, Bryce, and thank you for the invitation to speak today. For those of you who know Bryce, it was his birthday on Sunday, so happy birthday.
Thank you, Lynn.
A very warm welcome to everyone joining us online. It's really wonderful to be together. I'm sorry this couldn't be in person, but I hope that we will be able to get some discussion going at the end of my presentation. Thank you very much for joining me. I think in the earlier days of the virus, I think most people could not be faulted if they thought that this would bring geopolitics to a halt, or it would at least fade into the background. But I think what we've seen instead has been geopolitics continuing unabated and arguably even intensifying. So we've seen the narrative about COVID-19, its source, who's responsible for it and who's handling it better. That's really been a tussle, and that also part of that battle for the narrative has included whether an authoritarian state or a democratic state handles crisis better. So it's all been quite ugly, and activities in the South China Sea have also followed that general trend. They've not skipped a beat, and activities in the South China Sea have arguably intensified. Should we be concerned? I think this is something that should concern us all. First, because it's not merely a dispute over mere rocks and reefs, as some like to say, but it's something that's very quickly changing the balance of power in the region. And the second reason why it should concern us is that the rules-based order is being undermined. And this doesn't just affect the South China Sea and US-China rivalry there, but it affects global order and the ability to ensure that there's peace and stability, not just regionally, but internationally. So we should all care about what happens in the South China Sea. In my talk today, I'd like to cover several broad points. I'll first like to run through recent developments, and highlight why they are problematic. I'll then examine some of the recent, some of the responses of some of the main players in the South China Sea, and these include a recent set of diplomatic exchanges to the United Nations, and I'll conclude with some observations about the implications of what's happening in the South China Sea and the likely impact of the pandemic. Before turning to the recent developments, though, I think it's worth taking a step back to remind ourselves of the main rulings of the landmark tribunal ruling in the Philippines case against China. And this will highlight quite clearly why some of the recent developments are problematic, in particular from the perspective of international law. Now, in 2013, the Philippines brought a case against China under the United Nations Convention on the Law of the Sea, or UNCLOS. The landmark award was issued on the 12th of July 2016, so we're just a few weeks shy of its 4-year anniversary. Now, the award has been criticized as ineffective. It failed to resolve territorial disputes. China continues to fortify its the islands, the features it occupies in the South China Sea, and disagreement continues between the United States and China about various maritime rights and freedoms, as manifested in the US Freedom of Navigation Operations, or FONOPS. But I think it's important to note that the tribunal was never meant to resolve those issues. Its main contributions has been to clarify resource rights, and its main findings are twofold. I'm going to be pulling up a map, which should hopefully work. And I think all of you should be able to see the map of the 9-dash line to, I think it would be on your right. So the first set of rulings of the tribunal relate to the 9-dash line, which made its first official appearance in a map China submitted to the United Nations in 2009. It's not entirely clear what China is claiming by the dash line. For some, it's a claim to everything within the dash line. An alternative interpretation, it's that it's merely a claim to the groups of features, the 4 groups of features within the 9-dash line, as well as maritime zones compliant with them under UNCLOS. Beijing's rhetoric and actions, however, I think more often than not, imply that it's claiming everything within the dash line. And the tribunal ruled that insofar as China was claiming historic rights to the resources of the 9-dash line, any such rights were extinguished by the entry into force of the United Nations Convention of the Law of the Sea in 1994, given its incompatibility with maritime zones set out in the convention. And in this respect, it would mainly be the exclusive economic zone. Now, the second set of findings that the tribunal ruled on relates to the status and entitlement of features in the Spratlys, as well as to the status and maritime entitlement of Scarborough Shoal. Now, the Spratlys are in this map that you have in front of you. It's this group of features here. Scarborough Shoal is actually further up. It's just off the Philippines island of Luzon, so it's off the map. The tribunal found that all these features in the Spratlys are at most rocks entitled to a 12 nautical mile territorial sea. None of them, including the largest one, which is E2 I think it is, I can't actually see it on my map, but it should be around here, E2 which is, there it is, which is a Taiwan occupied feature. That's the largest natural feature in the South China Sea, and the tribunal found that that feature too was only entitled to a 12 nautical mile sea and not a 200 nautical mile exclusive economic zone. What the tribunal additionally found was that the Spratly Island as a whole cannot be considered a unit from which maritime zones are generated. So the impact of that, if it could be considered a unit from which maritime zones can be generated, we would be joining the outermost features in the Spratly Islands, forming it using straight baselines around it. And then from that huge kind of lasso, then measuring 12 nautical mile territorial sea, and beyond that outwards a 200 nautical mile exclusive economic zone. This would clearly generate a huge expanse of maritime claims, and the tribunal said no, only archipelagic states, and China is not an archipelagic state, only archipelagic states can draw straight baselines around mid-island archipelagos and claim maritime zones from that. So although the decision of the tribunal was only technically binding on the parties to the tribunal, to the case, namely the Philippines and China, it made clear that the other littoral states within surrounding the South China Sea as well were entitled to enjoy maritime zones, an exclusive maritime zone unencumbered from any Chinese 9-dash line or from any claim to an exclusive economic zone generated from features in the Spratlys or from Scarborough Shoal. So this is a very simple diagram prepared by a Filipino judge, which is why it's labeled West Philippine Sea. It's a very simple diagram showing the situation that was avoided, that was averted, as a result of the tribunal finding that no feature within the Spratlys generated a 200 nautical mile EEZ. So we see that this area of overlap in shaded in gray, that area of overlap doesn't exist. And what we do have instead, and this is the diagram that was prepared some time ago by a former colleague at the Center for International Law at the National University of Singapore, Yona Lyons. She prepared this diagram, which actually shows the 12 nautical mile zone around features that the tribunal thought was entitled to a territorial sea. So there you have that. As well as in light green and in orange, likely and potential and possible territorial seas from features in the Spratlys. So if you see, these are the areas of overlap, and they're far narrower than any area of overlap that would be generated either from a 9-dash line or from an exclusive economic zone generated from features in the Spratlys. Now, let's talk about the recent developments in the South China Sea. So despite the tribunal's ruling, China has sought to further strengthen its maritime claims in the South China Sea. This has taken several forms. Since around the onset of COVID-19, in the last 6 months or so, China has, first of all, encroached upon the exclusive economic zone of Indonesia, Vietnam, and most recently, Malaysia. These encroachments have involved sinking a Vietnamese fishing vessel and conducting survey activities within the Vietnam's exclusive economic zone. It's also involved survey activities in Malaysia's waters, harassing Progress Capella, which was a drill ship that was hired by the state oil company Petronas, Malaysia state oil company Petronas, to conduct survey activities in Malaysia's exclusive economic zone. This represented an escalation in terms of China's activities in Malaysia's waters. Prior to this, since 2013, China has had a near constant but generally low-level presence around a feature that Malaysia administers in its exclusive economic zone, Lukunir Shoals. But these recent incursions into Malaysia's exclusive economic zone constitutes active infringement on Malaysia's EEZ. Such actions by China clearly are in direct contravention of the tribunal's ruling, which clarified, as I mentioned earlier, that coastal states enjoy sovereign rights and jurisdiction over the exclusive economic zones unencumbered by the 9-dash line, which you can see here, as well as any claimed EEZ from the Spratlys. Now, second, China has also maintained a near constant presence around features occupied or administered by other countries, including the largest feature the Philippines occupies in the Spratlys called T2 Island. And it's not a very clear diagram because it's so detailed, but I think it's T2 Island should be around here. It's just a little bit outside of the Philippines EEZ. China's presence around such features is not necessarily unlawful. Countries have, user states have a right to innocent passage in any territorial sea around features, as well as high sea freedoms outside of these features. But the numbers and the persistence of Chinese vessels around these features suggests that they are aimed at intimidation and asserting greater Chinese control. China's activities have not been limited to skirmishes with Southeast Asian littoral states. What we've also seen is China's continued objections to assertions of maritime rights and freedoms by the United States and its allies in the waters of the South China Sea. And China's Ministry of National Defense recently, rather bafflingly in my view, issued a blanket objection to the presence of foreign powers in the South China Sea. So we see China seeking to exclude countries like the United States, but other countries as well, from the international waters of the South China Sea. Such objections are completely inconsistent with maritime rights and freedoms enshrined under UNCLOS. And this is a convention that China itself ratified in 1996, and the United States abides by as a matter of customary international law and domestic policy. China's objections to assertions of maritime rights and freedoms by the United States and its allies is particularly worrying, given an environment of heightened recriminations around COVID-19 and worsening US-China relations. What we saw in April, just a couple of months ago, was that the US and Chinese warships came within just 100 meters within each other. And this greatly increased the risk of incident. What this close encounter recalled was a near miss back in September 2018, when a Chinese warship came within about 41 meters of the USS Decatur. The USS Decatur was forced to maneuver to prevent a collision, and this took place amidst heightened trade tensions. So now with heightened tensions around COVID-19 and various other issues, it's a time for us to worry as well about possible incidents at sea. Now, some argue that what the US and China need are rules of engagement. My point is that we already have these rules of engagement. So in 2014, both the United States and China signed a memorandum of understanding for safety at sea and air. And this generally helped to minimize incidents at sea for a good 4 years. And it was only, as I mentioned, until in September 2018, when we had a near miss between the United States and Chinese vessels. Now, I'm going to stop the screen so that, because I don't have very much more to show you on that screen, but I'd like to examine regional responses now to Chinese activities to consolidate its position in the South China Sea. Now, Indonesia has had a fairly robust response recently to fishing incursions into its exclusive economic zone. And it sent 8 warships as well as Coast Guard to respond to Chinese fishing vessels and Coast Guard in its exclusive economic zone. Some have talked about Indonesia possibly reprising its role to lead ASEAN towards a stronger common response to Chinese activities in the South China Sea. However, I think under the Jokowi administration, we are going to see a staunchly nationalistic response as opposed to a regional response from Indonesia as it seeks to ring-fence its exclusive economic zone. In terms of Vietnam's response, Vietnam has sent Coast Guard and Maritime militia to protest Chinese survey activities and Coast Guard in its exclusive economic zone. It's also supposedly weighing up a case against China. I don't know to what extent it's likely to bring that legal case, but apparently talks of bringing a legal case have increased in recent months. The facts surrounding Malaysia's response is slightly unclear, but Malaysia's government has apparently sent government vessels to patrol around the West Capella, the drill ship that's conducting survey operations for Petronas company to counter Chinese harassment. By and large, however, I think Malaysia's response has been to seek to play down tensions with China. Its Ministry of Foreign Affairs in late April issued a statement that did not mention Chinese incursions into its exclusive economic zone, nor did it mention harassment of the West Capella. What it did say, however, was to urge a peaceful resolution of disputes in accordance with international law, including UNCLOS, and it warned against the presence of warships and vessels, which it said increased the potential for miscalculation. Now, this statement was as much a rebuke of China as well as the United States, which had sent warships to support Malaysia against Chinese incursions into its EEZ. Malaysia apparently was not very happy with this show of support from the United States, saying that this caused to generate increased tensions rather than reduce them. So it was hardly appreciative. While littoral states in Southeast Asia have sought to resist incursions thus, I think what we can see from the responses has been they sought to resist incursions, but also at the same time do so in a fairly restrained way that will allow it to, in other areas, maintain good ties with its economically and militarily more powerful neighbor. One area of progress that we've seen, and it's a relatively small area, although I don't want to overstate it, is that we've seen the recent emergence of a clear sense that apart from China, countries are all operating under a common understanding of the law. This is a likely unintended consequence of Malaysia's December 2019 submission to the United Nations Commission on Limits of the Continental Shelf. So this elicited quite a strong response from China, which in turn provoked responses from the Philippines, from Vietnam, as well as Indonesia. Now, China, in its statement in response to Malaysia's statement to the United Nations, said that it referenced its 9-dash line, it referenced its historic rights to waters within the dash line, historic rights, and it also referenced its 2009 statement to the United Nations, which, as I showed you earlier, contained a reference to the 9-dash line. So it mentioned historic waters, it referenced a statement which referenced the 9-dash line. In addition, China in that statement also appeared to be claiming maritime zones from the Spratlys as a unit, something that the tribunal in its decision in 2016 explicitly rejected, saying, no, countries, you're not meant to be drawing a straight baseline around these features and then projecting maritime zones from them. But this hasn't stopped China from referencing the possibility of these groups of features actually claiming maritime zones in the South China Sea. Now, the note verbal from the Philippines, Vietnam, as well as Indonesia in response to China make three things clear. First, they state that any claims must accord with UNCLOS. Second, that China's claims do not accord with UNCLOS. And third, that the arbitral tribunal's award in the Philippines a case against China is an authoritative statement of the law in this respect. Now, the Philippines and Indonesia made the acceptance of the tribunal's ruling clear, explicit. Vietnam's statement was implicit in its acceptance of the tribunal ruling. Together, these statements from countries, in my view, express a chorus of disapproval for Chinese maritime claims in the South China Sea. In an interesting turn of events, the United States as well issued a statement at the start of this month. So on 1st of June, the United States issued a statement, and its position as well is broadly consistent with the positions of the Philippines, Vietnam, and Indonesia, with two exceptions. With just one exception. What the United States statement failed to do, which the rest did, was to confirm its acceptance of the tribunal ruling that none of the features in the Spratlys were entitled to a 200 nautical mile exclusive economic zone. And the reason why the United States might have done this was because the United States also has claims to an extent to a 200 nautical mile EEZ from its territories in the Pacific, and I think it was reluctant to possibly have to give them up. A more positive aspect of the US statement has been its confirmation that low tide elevations, as well as submerged features, cannot be subject to independent appropriation. So if a feature falls, if a low tide elevation or a submerged feature falls within the territorial sea of coastal state A, then it belongs to coastal state A. If it falls within the EEZ of coastal state A, that state has jurisdiction and control over that low tide elevation or submerged feature. So for such features, location is everything. They belong, or the coastal state has rights over these features. It's different, of course, for rocks and full islands, which might be subject to independent sovereignty claims. Now, this has implications for features like Mischief Reef, which is a low tide elevation within the Philippines exclusive economic zone on which China has built a base. Jurisdiction and control of Mischief Reef clearly vests with the Philippines, and Chinese construction activities as well as militarization of Mischief Reef are clearly problematic. In terms of ASEAN's responses, we've seen a rather limited response from ASEAN, which has held out the Code of Conduct as the holy grail for the South China Sea. Unfortunately, it is plagued by several intractable issues, so few are actually expecting a meaningful Code of Conduct to be concluded. Negotiations nonetheless continue because it allows China to say that, look, Asian countries are managing their security problems well, and they do not need interference from outside powers. And in the meantime, China continues to militarize features in the South China Sea. Southeast Asian countries, or ASEAN, accepts the Code of Conduct negotiations because it also permits it to show that it is doing something to seek to manage the dispute between the various claimants as well as Indonesia and the South China Sea. I think ultimately I'm pessimistic about what a Code of Conduct can achieve, because even if, and this is a big if, even if we could resolve things like economic claims under the Code of Conduct, we will not see resolution to the territorial dispute, nor will we see resolution to the broader geostrategic challenge between the United States and China. So what are some of the implications of recent developments in the South China Sea? Now, Beijing's militarization of the South China Sea is sometimes regarded as inconsequential because they are vulnerable to US ships, aircraft, as well as submarines. Experts say that these are, extremely vulnerable to attack, and, installations and deployments in the South China Sea can easily be taken out by the United States. But I think it would be unwise to discount the advantages that China clearly gains in the South China Sea in situations short of outright conflict. Now, Admiral Phil Davidson, who was then Commander Designate of the Pacific, what was then called the US Pacific Command, in April 2018, actually testified that China is now capable of controlling the South China Sea in all situations short of conflict. Now, my view is that this probably overstates China's control of the South China Sea because US vessels as well as its allies' vessels continue to ply the South China Sea. But I think the thrust of his statement is an important one, namely that China has a very strong hand there. A Japan Ministry of Defense report has found that China's naval and air facilities in the South China Sea allow for a more robust maritime presence, boosting China's surveillance, intelligence, and reconnaissance activities, as well as other mission capabilities. It also finds that they help improve China's ability to enforce an air defense identification zone should it declare one in the future. Now, all these advantages likely go towards realizing what China's broader strategic objectives are in the South China Sea, namely to achieve strategic depth and reach to defend against adversaries, as well as to protect access to the critical Malacca Straits. Now, I think China has also gleaned important non-military advantages that are often overlooked, and these are twofold. The first is that they have deterred regional countries from putting up a strong resistance to Chinese activities and Chinese claims in the South China Sea. And the second is that they have greatly undermined US credibility in the region. I think the view in the region is that while the United States was asleep at the wheel, China presented the world with a fait accompli. I think moving forwards, COVID-19 and developments since are likely to exacerbate these trends. I think it's likely to reinforce the propensity of weaker governments in the region to rely on China. Even if Southeast Asia manages to avoid the worst health consequences of COVID-19, I think we will see the economic repercussions of the pandemic weigh very heavily on the region. And so countries, certainly countries like Cambodia and but possibly as well, Indonesia, Malaysia as well, look to China for a boost to its economy. I think COVID-19 has also done great harm to the United States' reputation, and it reinforces views in Asia that the United States is a power that's declining relative to China, and they questioned the extent to which they can rely on the United States to play a leadership role in the region if it barely appears able to put its own house in order. Beyond the issue of capacity, I think the United States demonstrates a clear lack of political will to any leadership role within the region or outside of it. When we saw COVID-19 hit US shores, it seemed to abandon its leadership and regional role. It seemed even to abandon any sense of responsibility as it fumbled and stumbled its way towards a response to COVID-19. So I think I'll stop there, and I look forward to any questions that anyone has. Thank you.
Okay, fantastic. We've got a lot of questions already, but because I'm the chair, I'm going to go with my own question first. So UNCLOS. My question relates to China and UNCLOS and the way that China negotiated UNCLOS. Now, my understanding is that the 9-dash line, and it's been through various iterations, was first put forward by Chiang Kai-shek way back in the early post-war period. And UNCLOS was, of course, the first international treaty that China negotiated on or participated in. If China has all along maintained that the 9-dash line is, or the territories within the 9-dash line are Chinese territories, and my understanding is that it has, how did it reconcile that with its negotiations when it was coming to terms with UNCLOS?
I think the first point to note is that UNCLOS does not deal with competing claims to sovereignty. So it's not going to tell, if you look, I don't have my text with me, but if you look at the text for the convention, it says nothing about how to determine whether country A or country B has a better claim to a particular territorial piece of territory. What it does do is it determines maritime rights, as well as, so how much what you're entitled to claim from certain features, as well as your passage and freedoms of the sea. So that's what UNCLOS deals with. And so I don't think China had difficulty reconciling UNCLOS together with its territorial claims in the South China Sea, because UNCLOS said nothing about its and continues to say nothing about its land, the ownership of land features in the South China Sea. let me caveat that, because even though UNCLOS says nothing about who has a better claim to sovereignty over a particular land feature, it does say something about whether certain features are entitled to a claim of sovereignty. So rocks and islands clearly are entitled to an independent claim of sovereignty. So even if it is found within, say, the exclusive economic zone of country A, it can technically belong to country B. However, for low tide elevations and submerged features, so things that you can't see at high tide, these features that form part of the landmass of the country that, in a sense, that it's close to, I mean, just simplifying it a lot. So if it's within the territorial sea of country A, it belongs to the country A. And country A also has rights and jurisdiction over it if it's within the exclusive economic zone, within its exclusive economic zone. So that's the extent to which UNCLOS actually touches on issues of sovereignty, but it doesn't determine who has a better claim to competing sovereignty, who has a better claim to a particular land feature.
Okay, well, kind of related to that point, we have a question from Andrew Farron, who I believe was the branch president of our Victoria branch at some stage. He asks whether you did cover this a bit in your talk, but whether the arbitral decision will aid other states around the region in coming to terms on their competing claims, because of course the competing claims in the South China Sea are not just China versus everybody else, but everybody else versus everybody else. So are there features of the rulings that that will lead to greater resolution of those disputes?
I think what it does is that it clearly limits the extent of dispute. So we're not talking about, you know, huge overlapping exclusive economic zones, or a huge 9-dash line overlapping with the EEZ of coastal states. What we have now, and you saw in that diagram that I shared with you earlier, what we have now are very small overlaps of territorial seas within the Spratly features. So I think that helps limit the scope of dispute in the South China Sea. And the tribunal ruling also helps countries like not the Philippines, because that, I mean, it clearly helps the Philippines, but it also helps countries like Indonesia, Vietnam, Malaysia, who can now rely on the ruling to say, hang on, China, get out of our EEZ, because the tribunal ruled that you cannot claim historic rights within the 9-dash line, and you cannot claim any EEZ from any of the features in the Spratlys or groups of features in the Spratlys. So what it has done is it reinforced, in a sense, the boundaries, the limitations of its EEZ, and said, this is ours and not yours, China.
Okay, very good. Right, we have a number of questions. Where was it? Can you scroll down? Sorry, Phoebe. I've lost the question. Yeah, there it is, stop. Okay, so that's right. So one of the things that has been mentioned probably a number of times by China, but probably should be discussed anyway, is the position of the United States on UNCLOS. I mean, the United States has not ratified UNCLOS. Is there, does the US have any credibility when telling China to abide by international law when it refuses to sign the treaty?
It certainly undermines US credibility, and that's why I think many international lawyers are unanimous in urging the United States to accede to the treaty. And it's not just international lawyers, but also many within past and present, maybe not present, but past administrations that have urged the United States to accede to the treaty. So it does hurt the United States because it is seen as having double standards. That said, I think the United States, since the Reagan administration in 1983, has made very clear that it abides by UNCLOS as a matter of customary international law. And I think US behavior by and large has shown that it does do so.
Great. I'd like to talk now about collective action or or cooperation within the region. What is your sense that nations around the region are starting to push back against China? There was a lot of optimism, and you talked about this at our forum as well, about, for example, the declaration, or what was it, the ASEAN view on, what was it, the ASEAN perspective on the Indo-Pacific, standpoint on the Indo-Pacific, was it? That was seen as a kind of sign that the ASEAN nations had adopted the language of the United States, Australia, and others that talk about this Indo-Pacific concept, which of course is something that is set up to deal with the rise of China. Are you optimistic? Well, I mean, you have covered it a little in your talk already, but are you optimistic that the Southeast Asian nations, through this instrument, are coming to some sort of understanding that they have to cooperate with one another in order to deal with power politics in the region?
Yeah, this is a broader question beyond the South China Sea. So on the South China Sea, I think we're seeing, as I mentioned in my talk, generally national responses to the problem. So instead of working either within ASEAN, with the exception of the Code of Conduct, but instead of working within ASEAN or even within groups of countries who are interested in putting forward a stronger response to China on the South China Sea, countries have generally sought to protect their own EEZ and not cooperate with other countries in doing so. That's within ASEAN. But you pointed out the ASEAN outlook on the Indo-Pacific. This was a statement that was issued last summer. I think it was in June or July last year. And you ask if that demonstrates greater cooperation within ASEAN. I think yes, to a limited extent. I think ASEAN understood that the United States and some of its allies were very keen on this concept. And they wanted a say. I think they rightly decided that in order to have a say in shaping this concept, they needed to at least say something about it. So what they did was issue this statement. I wouldn't put too much credence on the statement in the sense that it's not a muscular response to China. What it was a fairly balanced document, which, yes, adopted Indo-Pacific terminology, but also talked about the importance of infrastructure development in the region. And this was a clear nod to China. The ASEAN outlook on the Indo-Pacific also did not explicitly mention the Quadrilateral Security Dialogue, or the Quad, and instead talked about the importance of economic integration and connectivity. It reasserted ASEAN centrality, and also talked about the importance of international law and a rules-based order, I think. So it was a fairly, it was a fairly balanced document, certainly nothing that thumbed its nose at China or was forceful in any sense. I think it was seeking to reclaim part of the narrative on the Indo-Pacific and seek to shape that conversation. So I think that's probably its contributions. It wasn't insignificant, but it wasn't. It probably can't be seen as anything more than that.
Okay, you mentioned an air defense identification zone, the threat that China would declare an air defense identification zone over the region. How likely do you think that is? And Gordon Arthur asks, if it is declared, what can and should ASEAN, USA, and other nations do in response? Would it be a kind of breaking point in the region? Is that the point where international legal action would be a lost cause because China would continue to ignore it?
Thanks for that question. How likely is China going to declare? How likely is it that China will declare an air defense identification zone, or ADIZ, over the South China Sea? I don't know. There was talk about it when China declared an air defense identification zone over the East China Sea in November 2013. Countries were very worried that China would do the same over the South China Sea. After that, talk about China doing so over the South China Sea died down, possibly because of the pushback, but possibly also because China understood that did not have the ability to enforce such an ADIZ. However, I think in early April, end March, early April, the Taiwanese Ministry of National Defense actually talked about China declaring an ADIZ, and that was followed up by some news reports that sought to play it down. So I don't know to what extent that was just, something that an official mentioned in passing, perhaps in response to a reporter's question, and that was taken out of context, or that's something that we definitely have to worry about. My view is that China's unlikely to do it right now because I don't see them being able to enforce it. So that's, although we should keep an eye on it, I'm not sure that that's something that's top of China's agenda right now. In terms of what the US and others can do, the thing with ADIZs, air defense identification zones, is that their legal status under international law is not clear. It's neither permitted nor prohibited under international treaties. International customary law is unclear about its legality. And the fact is, there are quite a lot of states around the world, including within Asia, that have air defense identification zones. Now, how a lot of them rationalize it is that they say that it's only necessary for aircraft that seek to enter the territorial airspace of their country. In the case of the 2013 air defense identification zone that China declared over the East China Sea, that was not limited to aircraft seeking to enter Chinese territorial airspace. It was also not limited just to civilian aircraft, but also extended to military aircraft. And I think the concern was that China would seek to circumscribe the sorts of activities that aircraft could conduct. So under international law, they can conduct intelligence reconnaissance activities in the exclusive economic zone of states, because that merely permits states exclusive economic rights, not security rights. But countries were worried that China, in its declaration of an ADIZ over the East China Sea, would circumscribe the ability of aircraft to conduct intelligence operations. If it did it over the South China Sea, I think the concerns would be the same, namely that it would be too wide a limitation on countries, and countries would clearly object. I don't know whether it means that international legal action would be rendered redundant, and China can't be trusted to adhere to legal action anyway, because in this case, as I mentioned, it's not clear. The legal status of an ADIZ is not clear in international law. I think I would argue that the legal action does matter and has mattered. So I think the Philippines case that it brought in 2013, and that was the award was issued in 2016. I think the Philippines case has clearly it has clarified the rights and obligations of states in the waters of the South China Sea, and has been very helpful in that respect. It has also been helpful in legitimizing the claims of coastal states over China's claims. So I wouldn't diss legal action.
Okay, well, on that point, there's a question here from Stephen Gould Martin. He says, what is the likelihood that China will join an arbitration with Vietnam? His understanding is that they may do so as they didn't against the Philippines and thus lost. And if they participate and lose, will that affect their requirement to abide by the decision with the Philippines? Is it a case of China having learned their lesson with the Philippines case, and might be looking at a different approach with Vietnam?
So you're saying that the question was, thank you, Stephen, for your question, but could you clarify the question? So the question is whether or not China will join with Vietnam in legal action.
No, I believe the question is whether they will take part in an arbitration if Vietnam calls China to the court.
Oh, I see. On whether they'll take part in the action, I think it would be very prudent for China to take part in the action. I think part of the problem problems it faced in the Philippines action against it was that it didn't participate, and therefore, didn't have a say in the choice of the judges. It didn't have a say, or rather the arbitrators, it didn't have a say in how the legal arguments were crafted. And I think if it were part of the decision, it would be able to push its legal argument a little bit better. And also, I think it increases the credibility of China rather than looking like someone who won't participate in something it thinks it has no hope of winning. It's a better sport in this case. That said, I'm not sure the extent to which, even had China participated in the 2013 case that the Philippines brought against it, that the outcome would be any different. I think it would just have had a better chance of putting forward better arguments. By and large, it put forward all the arguments that it would have wanted to put forward in the Philippines case outside of it. So in 2014, it issued a position paper. Its Ministry of Foreign Affairs issued a position paper setting out the legal arguments that it thought worked in its favor, and the tribunal actually dismissed them. It appears that Bryce might be frozen. So I have become my own moderator. Let's see, I'll take the question from Patrick Moore. Would China respect any rules of engagement? She hasn't respected agreements regarding Hong Kong. As I mentioned earlier, it hasn't. It did for a while, it did for a good 4 years, respect rules of engagement, but it has also recently shown signs that it's quite willing to be less observant of them. So as I mentioned, in 2018, in September, it disregarded rules of engagement at sea. And that caused a near miss in the South China Sea. Recently as well, it was a very close encounter between a US and Chinese warship. So I think you're absolutely right in pointing out the fact that, a power that does not adhere to rules in one area is very unlikely to adhere to rules in another area. And that's why we should be concerned about observance of international rules and law, regardless of the region and regardless of where we find ourselves in. And in the case of Hong Kong, yes, it's quite sad what's happening there. And I think the number of options for countries is quite limited. I think the US, if it passes sanctions in respect of Hong Kong, it's not clear that this will actually help Hong Kong. It's likely to hurt the United States because I think it enjoys a trade surplus with Hong Kong. So it's quite a difficult situation there, but I leave that to others who work more closely on Hong Kong.
Thanks, Lynn. Sorry for dropping out there. You handled yourself very well. Let's go now to Philip Mines. I guess the Philip Mines' question concerns the question of US force in the region. I mean, if there is one thing that China perhaps does respect, it is military force. At least that's the argument amongst a number of hawks in the United States. Philip Mines asked, does the United States Defense Treaty with the Philippines commit the US to the defense of Philippines' claims on the Spratly Islands? And does that include any of the other treaties does a similar situation exist for any of the other treaties that exist around the region?
The US-Philippines Mutual Defense Treaty only covers Philippines territories, as well as I think its armed forces. The United States does not take a position on who has a better claim to sovereignty of the land features in the Spratly. So I would argue that I think the United States is unlikely to say that the defense treaty covers some of these features in the Spratlys, but I could be wrong. They could decide that it does and that it wants to get into the fray. But I think if the United States takes no position on competing sovereignty claims to land features, then it would be reluctant, at least on a legal basis, to say that the Mutual Defense Treaty covers these territories.
Okay, we have time for one more, I think, and we'll ask Christopher Skinner's question. Christopher's a member with us at New South Wales. He asks, from your perspective at IISS in the South China Sea, is the South China Sea a relevant place for Australian involvement? What should we be doing? Should we be getting involved in freedom of navigation operations or participation in undersea resource exploration or similar matters?
I think all countries who are interested in a rules-based order should be wondering and thinking about how they can better contribute to a more stable and peaceful South China Sea. Australia, I think, plays an important role because it's an important middle power in the region, and more so than many other powers. It's close to the region, so it's got a kind of abstract interest in the South China Sea, but also a very real and concrete interest in developments there, since it's so close to home. In terms of FONOPS, so I think Australia thus far has not conducted any formal, what the United States calls freedom of navigation operations. This is a bit of a misnomer because it does more than push back on challenges to navigation rights to travel from point A to point B. What the US Freedom of Navigation Operation does is it challenges excessive maritime claims, such as the insistence on prior notification or authorization before a warship can conduct innocent passage through the territorial sea of a state. It also pushes back against claims that countries are not entitled to conduct military exercises in the exclusive economic zone of coastal states, as well as the drawing of, and it pushes back against the drawing of straight baselines when the conditions for such straight baselines, which would enclose a lot of water as internal waters of a state, because these conditions are not met. So that's what the US Freedom of Navigation Operation seeks to challenge. These are some of the claims that, excessive maritime claims that the program seeks to challenge. Australia hasn't done any of those, to my understanding, but what it has done is presence operations in the South China Sea. So in the recent Chinese incursions into Malaysian waters, for instance, there were 3 US warships, but also an Australian warship that kind of accompanied the US warships to support Malaysia in pushing back against Chinese encroachments into its EEZ. And I think those are important things for Australia to be doing, first because it has the capacity, so it's able to, but also because it has an interest in doing so, because I think a rules-based order is important to everyone, and a rules-based order in the South China Sea is it should be particularly important to Australia. And I think what happens in the South China Sea, I mean, we can't really now look at things as if they're unconnected now, but if we look at activities in Chinese activities in the South China Sea, or pressure brought to bear on Australia, in a sense, different sides of the same coin, and what all countries should be working for, China included, is a rules-based order that works in favor of all countries, large and small.
Great. That's a positive note, I guess, to end on. So let me end by thanking you. It was a fantastic talk, and in order to thank you, I'll once again plug your Asia-Pacific Regional Security Assessment. Get it now; it's available on Amazon, and I hope to see you again at some stage soon.
Thanks so much, Bryce. It's a pleasure to be here with you.
Okay, so don't go away. Coming up, we've got a list of our upcoming events. We've got some pretty exciting events coming up, as well as an announcement that I'm happy to make on this webinar, that we are going to soon have events in the Northern Territory, which we haven't had for a while. And our first inaugural event there will be with Kevin Rudd, the former Prime Minister of Australia. We also have Chris Batten, the former Governor of Hong Kong, in conversation with Gareth Evans, the former Foreign Minister of Australia, and that's being organised by our Tasmania branch. So stick around and see what we have available, and if you do want to keep yourself updated on the events that are coming up, go to internationalaffairs.org.au/events and take a look. Thanks again, Lynn, and we'll go with the outro.